Good morning. This marks the start of the December 18th Ohio Elections Commission meeting. We want to thank you for your grace as always, as we gather intel of who's online, who's present in person, just to make sure that we can honor your time. Today should be a pretty efficient meeting, as it is our last meeting. So we're going to go ahead and take the attendance to get started.
Mr. Stoutberg.
Here.
Mr. Lyle.
Here.
Mr. Knight.
Here.
Ms. Tavares.
Here.
Vice Chair Davis.
Here.
Chair Hagan.
Present.
Mr. Kirchner is not present. He has business opportunities that keep him from attending. Let's put it that way.
Good excuse.
Second. All in favor?
Aye.
Any opposed? Seeing none, the motion passes unanimously. Okay, we're going to go ahead and move on to approval of the meeting minutes. Are there any questions or is there a motion? Second. Okay, all in favor? Aye. Any opposed?
Abstention.
Thank.
I think. Four passes 4-0. Okay.
Yes, correct.
All right. Okay, very good. Moving on, we're going to just stay in order today since we have a short caseload. We're going to start with the preliminary reviews. Board of Elections referrals. Item number 1, case number 2025R-161. And online, we do have Floyd, and in person, we have Helen Laurie.
Chair, members of the commission, there's a couple of cases where it was originally for failure to file addendums to certain pre and post reports. All of those reports have been filed according to the Cuyahoga County Board of Elections. The campaign committee is in compliance. They are satisfied. We did receive a response yesterday, which all of you have updated ICWs in front of you, in which the candidate acknowledged that addendum requests were received, but not initially filed, but all reports have now been submitted. Certainly we could, my recommendation is to consolidate these two cases, 2025 R-161, 2025 R-236, find a violation, impose a fine of $750. Some of that is in consideration of the fact that there's a $500 fine outstanding, and that would take this into consideration. Certainly we could hear further from Ms. Laurie and or Mr. Floyd if the commission is so inclined.
I would assume the will of the commission is to hear. Is everybody okay?
Thank you, Elections Commission and Madam Chair. Just want to say that we're happy to have submitted all of the addendum and amendments to the reports. And we accept the executive director's recommendation of $750 in consolidation. Thank you. And I'm here to answer any questions.
Okay, very good. We thank you very much. Are there any questions that commission members have? Seeing none. Mr. Floyd? Yeah.
We'll give Mr. Floyd an opportunity to speak if he was so inclined.
Sure do. Mr. Floyd, if you would like to provide any testimony, please be sworn in accordingly.
I have no testimony.
Sorry, the optics aren't great here for connecting with the camera, so if you want to, you can raise your right hand, but you'll need your mic unmuted. Can you guys give me a little direction if he's able to?
He's unmuted.
Hear, see, be
There you go.
unmuted, be sworn. Great. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
He may not be unmuted.
Mr. Floyd, we couldn't verbally hear you. We can see your hand up.
All right. Floyd,
Can you hear me now?
Sometimes when people leave the room and rejoin by the link, that can help. Give them just a little bit of grace here.
Speaker are we looking for? Who's got a speaker here?
It's
I do.
supposed to be Chris.
Chris.
So,
And it's unmuted. It's my volume's up as well. Just
Not yet, no.
I'm admitting him back in.
okay, Mr. Floyd, can we hear you now?
No, I can still see a muting communication.
There he is. Can we hear you now,
Can
sir?
you hear, can
Nope.
you hear me?
Is this just a problem with somebody not having volume up on our end? Just, we want to
the volume.
double check that.
The volume is up on. Now try it.
Can you hear me?
Would you mind trying to speak again? I'm so sorry for the inconvenience.
That's all right.
There you
There we go.
Wonderful. Okay, sorry for the delay. If we could just repeat and maybe it's more.
All that to say that I really didn't have anything to say.
All right, well, you know what? That is just how the commission functions. So thank you, sir. Appreciate seeing your kind face. Okay. Are there any questions? Commission members? Okay, seeing none, is there a motion?
I'll move the executive director's recommendation, Madam Chair.
Second.
Okay, all in favor?
Aye.
Any opposed? Seeing none, motion passes unanimously. Okay, moving on to item number 2, case number 2025R-235.
Madam Chair, members of the commission, this is also a failure to file case. All of these matters, by the way, were addressed initially, well, not initially, even were addressed in a continuation matter at the December 4th meeting, were continued. And I informed all of the candidates here that the matters would be addressed today with the expectation that there would be a resolution. I've been in, as it relates to this case and the next 3 cases, essentially, I have been in contact with Cuyahoga County Board of Elections. They have indicated that there has been no subsequent filings submitted by any of the respondents here. And so my recommendation, as you can see, is to consolidate as it relates to item 2025 R235, or case number 2025 R235, is to consolidate this matter with case number 2025 R004, find a violation and impose a fine of $200. I'll be glad to answer any other questions that the commission may have.
Are there any questions of the commission members? Okay, seeing none, is there a motion?
I'll move the recommendation of the executive director.
Second.
Okay, very good. All in favor?
Aye.
Any opposed? Motion passes unanimously. Now, Bill, you referenced the next 3 cases.
Right. The next case is Michael Hardy, case number 2025 R-237. Again, this is for a failure to file case with Cuyahoga County Board of Elections. When I had conversation yesterday morning, actually, with staff at the Cuyahoga County Board of Elections, the report had not been filed. If you look at this, there was a prior matter in which a fine was imposed. That fine has been paid recently, but we still have this matter outstanding. And so my recommendation is to find a violation and impose a fine of $500. I'll be glad to answer any other questions the commission may have.
Okay. Very good. Just an administrative keeping or housekeeping item. You skipped over item 3, case 2025 R-236. Was that
That was-
intended to be a part
That
of
was consolidated.
one?
That was
Okay, so, all
consolidated.
right,
Yeah,
okay.
That's fine.
Okay.
not a problem.
All right, very good. So in relation to the Hardy case, we don't have anybody present that I'm aware of online or in
That is
person.
correct.
Okay, very good. Are there any questions to the executive director? Not, is there a motion?
I make a
Way
motion.
forward.
I make a motion to accept the executive director's recommendation.
Second.
All right, all in favor?
Aye.
Any opposed? Okay, motion carries unanimously. And lastly, I would assume we're gonna group these 2 Lopez and Mini cases, 2025 R-242 and also -279.
That is correct, Madam Chair. These 2 are again, referrals from the Cuyahoga County Board of Elections, for failures to file. I think it's primarily addenda. Let me double check. Yeah, for addenda for prior reports that were not submitted. If you recall, both the candidate, Ms. Lopez Inman, and the treasurer, Ms. Graves, addressed the commission on December 4th and indicated they were anticipating filing the reports and getting this matter resolved. But again, after conversation with the staff at the Cuyahoga County Board, those reports have not yet been filed. And so my recommendation is to consolidate these cases, find a violations, and impose a fine of $200. I'll be glad to answer any other questions the commission may have.
Commissioners, are there any questions or is there a motion?
I'll move the recommendation of the executive director.
Second.
And all in favor?
Aye.
Any opposed? Very good. Motion passes unanimously. We're going to move on to the preliminary reviews, specifically the Secretary of State referrals. Item 7, case 2025S-037. It looks like Mr. Jensen is online.
Madam Chair, members of the commission, this is another matter that was originally a failure to file certain reports. Mr. Denson emailed me this morning indicating that reports have been filed. I confirmed that with the staff at the Secretary of State's office. Obviously, they have not had an opportunity to audit those reports at this point. My recommendation, as you can see, currently is to find a violation, impose a fine of $500. The couple of factors went into that. One, when I was making this recommendation, the reports had not yet been filed. There is a $200 fine outstanding that had not been paid. And so my recommendation may change. We can certainly hear from Mr. Denson, who is online, if he is sworn. And Mr. Katz is here on behalf of the Secretary of State's office to further address this matter if the commission desires to hear from him.
So it's a will of commission to allow both to provide input. Mr. Katz, do you have?
First?
I do.
Okay, yeah, please. Let's hear from Mr. Katz, and then we can hear from Mr. Denson.
Thank you very much. So first, just thank you. The executive director's correctly contacted our office while I was on the walk over here, spoke to somebody else who gave him bad information. Mr. Denson has had multiple reports missing. And while he did file a older report, the 2023 annual report this morning, he has not filed a report that is the matter of this complaint, the 2024 post general report. So I apologize that that information was passed along, that she was not aware of the complaint that we actually have in front of us today, which is the missing 2024 post general report, which has not been filed as of the 2 minutes ago. She was messaging me, letting me know about the phone call. But good morning. This is our 5th time Mr. Denson has been on the agenda for hearings. July 22nd, October 7th, November 6th, December 4th, and now December 18th, all for a simple failure to file a campaign finance report. Should have taken care of more than a year ago. Mr. Denson was on the ballot November of 2024, and thus he owed a 2024 post general report. He is the treasurer for the committee and filed a 2024 pre-primary and 2024 post-primary reports with ending balances of a little over $10,000. However, he has not filed reports since then. He was contacted by email and informed of his missing report back in February, on February 26, 2025. He also personally contacted our office to request filing guidance back in October, using the same email address that we used when contacting him previously. And yet no report has been filed as of today. His report is now 371 days late, with the up to $100 fine amount of $37,100, or a reduced $25 a day fine would be $9,275. While our office would not expect to see a fine in that amount, his intentional and ongoing disregard for even basic campaign finance reporting deserves more than a mere slap on the wrist that a remorseful offender would typically receive. Happy to answer any of your questions. Thank you very much.
I do have one question. I just wanted to clarify. So you were saying the information that the executive director received from your office was inaccurate this morning at first, but now has been corrected.
So the information was correct. However, they were talking about a different report. So
you referenced a different case. She was referring that.
I'm not sure of what he said. I just know that she gave him information based on a filing that our office received about 10 or half hour ago involving a 2023 annual report. That is not the subject of today's complaint. Today's complaint is a missing later report, the 2024 post general report.
There was some confusion in the communication.
Yep, he has
very good.
other issues that we are not addressing today. It's good to hear he is taking care of one of those outstanding issues, and we will be in contact with him about that. But that is still not a missing report. That is the subject of this complaint.
Very good. Okay. Commission members, do you have any questions for Mr. Katz while we have them?
Thank you very much.
Thank you. Okay. Mr. Denson, I assume you may want. Yes. Okay, very good.
Can you hear me? Am I able to be heard?
Very low.
My volume's all the way up.
Okay, I've turned mine on.
Hello,
Okay,
Yeah, just speak up, Mr. Denson.
okay, please raise your right hand.
can you hear me?
Yes.
Yes. Do
Okay,
you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Thank you.
Go ahead, sir.
Okay, thank you to the commission and, I wanted to was hoping to get this headache put to rest today. I have had a whole, I'm sorry, I'm hearing an echo.
Yeah, it's gonna be, there's gonna be a bit of an echo, but I think just try to work through that.
Okay, I've had a whole slew of things that have went on that have placed a lot of confusion for me being able to take care of everything. I had an original
Hold on,
treasurer.
hold on.
Speak slowly.
This is unnecessary.
Is
Just
that
one of these
volume?
components needs to be muted.
He muted it.
All right, go ahead, sir.
Okay. I've had a change of treasurers that had come into play and things didn't transfer over, which left me really confused. And it's taken me some time to get all the records together to actually bring everything current. I did just file, because I had to wait literally until this morning. I was dealing with the bank to get some records last night and was able to get what I needed this morning once they opened. And I did go on and was able to file the report. They didn't open until 9 o'clock. And so I got the amended report done, and it's showing if I do the search that I've also done the 24 report as well. So I did file the pre-primary for 24 and the post-primary for 24. If there's another one that's outstanding, then I'm unaware of that. Again, with the changing of treasurers and stuff, I haven't been getting the communications. So it was hard for me to track actually what needed to be done because it wasn't being sent directly to me. And there was no more communication with the former treasurer of the campaign. But I would like to obviously put this to rest. It was my indication based off of a conversation I had with the Secretary of State's office this morning that the reports that needed to be filed were the 23 and 24. So I did the pre-primary and the post-primary. If there's another one that needs to be done, because I have records I need now, I'm happy to be able to go in and do so. Right now, something in addition needs to be done, but I would like to get this shored up so I can put my headache to rest.
Well, the referral was, the current referral that we're dealing with was for the failure to file the 2024 post-general election report. And, you know, if you heard Mr. Katz, he indicated that they're not reflecting that report has been filed, and he continues to assert that particular position. So that is still outstanding. You may have submitted other materials, but they don't reflect that as having been submitted.
So, and forgive my ignorance on this, because although they indicated that this was never my space, it was always handled by the treasurer of the campaign. So for 24, there's the pre-primary and post-primary. And so what you're saying is that there's another one after the post-primary?
Yes, the post-general election report. Did you lose the primary? Or what? What happened there? No, you won the primary, so you ran in the general election. Is that correct?
That's correct.
Okay, well then, as a candidate, you are obligated to at least file a post-election report. You may have been also obligated to file a pre-election report, but that could be subsumed in the post-election report. But a post-general election report for 2024 would be required. If you filed that, then no annual report would be required. But presuming that to be the case, that means your campaign committee is still open, which means that right now, as we're talking, the expectation will be that you file a 2025 annual report.
Okay, so I guess then in that case, because what I have filed is the 2024 pre-primary and the 2024 post-primary. So to follow you, you're saying that there also needs to be a post-general for 24?
That is correct.
Okay, that part I did not know. Otherwise, I would have done that at the same time I did the post.
The post-primary
okay.
report, understood.
Right.
Okay.
Okay, so that, in that case, then that's the confusion, and that is my confusion there. But of course, now being out of office and just circumstances being different for me, and handling myself, like I said, this is my first time having to do it. So there's just been a lot of confusion there and a lot of fact finding to gather things, because again, it had been a change of 2 different treasurers since I've had an active campaign committee. So that wasn't an easy task to follow either, to get all those things, because I was never a designee that was on the accounts or anything like that. But got through most of that, and I would like the opportunity, if so, to just file the 2024 post general to resolve this matter, and I can do that today.
How much, and this is more a curiosity question than anything, what's the situation as it relates to funds in your account?
It's around 10,000.
So it is still around $10,000. Okay. So with that being the case, just be aware, along with filing the 2024 post general, that will reflect your activity from the post primary period to the through the election period. You're going to be required to file an annual report for this year. And unless you can get rid of $10,000, in the next 13 days, that would carry you into 2026 as well. And you're going to need to file a 2026 annual report, like I said, unless you can get rid of all that money, because you can only terminate if you get to a 0 balance.
Right. And the intention is right now, just because I don't know what the future holds, is to keep it active. But I would like I said, I would like the opportunity to get current with the 24 post, now that I know that's something that needs to happen. And having the knowledge, I think my understanding was I would have to do the 25 annual that would be due around the beginning of January.
The end of January 31, or the last business day in January is when an annual report is required to be filed.
I think we've had some pretty productive dialogue here that's created some clarity on the situation. May I ask, or do any other commission members have any questions? I do have a question. May I ask, have you had communications with the Secretary of State's office and your local board on these matters specific to this case as it stands? Or who have you been communicating with to help you along in this process since you've been poster treasurer handling the matters?
Sure. There was a communication with the Secretary of State's office, and there was a gentleman that I was working with. Off the top of my head, I cannot remember his name, that gave me some clarity to start moving forward so records could be found, like what I needed to track down. And then just for my clarification again, which is why I needed the continuation from last meeting, I haven't had the communications coming directly to me, so I didn't know exactly what was needed. But based off of, once I had the clarity of speaking to the Secretary of State, the gentleman that I can't remember his name, gave me some things, and I was able to get in and log in and see what had been filed and everything. It pretty much made it clear for me what needed to be done. So that's when I began the process of getting all my records up. With regular banks, I think it's easier to get records. With credit unions, it's a little bit different in how long it takes to get records, and it's more of a headache than you ever want to deal with. But once I was able to track all that down, that's what got me on the road to getting everything literally up to today, as I mentioned earlier. And this morning, I did speak with the Secretary of State's office to get clarity, and that's when I was told about the reports that I went in and made sure were done, which kind of, it reflected the record that I came up with myself of this is probably what needs to be filed. And so that's what I was trying to be compliant with before today's meeting. But now I'm learning that it's also the post general, which, like I said, I'm willing to just go in and do today.
Okay, we appreciate your honest dialogue. Are there any other questions of the commission members? Okay, seeing that, it looks like Mr. Katz would like to make a statement.
Mr. Denson says there's been a change in treasurer. He's been the treasurer for his committee since at least January of 2023. I believe he's talking about hiring a law firm that assists in matters of this sort that no longer represents him. But as for, he has been the treasurer for this committee for years and has been obligated to do these filings. Mr. Denson, a warning for you. We only filed an allegation of missing a 2024 post-election report because we don't know whether you raised or spent more than $1,000. As Phil was saying, if you raised or spent more than $1,000 before the election, you also owed a pre-general report, but we don't make that allegation because we don't know whether you did that or not. And so just please contact our office after this. And Robert Smith, who I believe is who you've been talking with, will be more than happy to walk you through those issues of those reports and making sure that you are able to timely file before the next annual report in January. But just restating again, the original argument of a report was due, it hasn't been filed, and we ask that any appropriate fine be levied in this case.
Mr. Denson, before you attempt to reply, just for process sake, are there any questions, Mr. Katz, as regards to this? I do have one question. Did he receive direct communications from your office to his email, personal address, those types of things? Because he's stating he didn't. So I'm just curious where the balance of that is.
Same email address, sdenson87 on Rich's email, public record, but it's the same email that he used to contact the committee and contact our office again since then. Received the reminders about you missing reports.
Okay. All right, very good. Mr.
Madam
Den-
Chair,
Oh, yes.
I now
sure.
have a follow-up
Yep,
question
sure.
to that. So, Mr. Katz, you're saying that there has been communication back from Rep. Denson to your office using that same email address? It's the same chain, or that's just the email address that everything has been going to?
For sure, that's the email we used to contact him. He contacted us in October using the same email address that we used for him. So yes, he emailed us from sdenson87@gmail.com.
Okay, I wasn't trying to get you to say it, but
How the whole. Okay. All right, very good. Any other questions? Okay, all right, seeing none.
Go ahead, Mr. Denson wants to- Go ahead, Mr. Denson.
So the designation of treasurer has, to my knowledge, because I was confused I kept being told that I could do it online, but I have not actually submitted anything to change the designation of treasurer. To me, it was still under the second treasurer that was also a law firm that represented me. So I know I heard you say about I've been since 2023. It's my intentions that I want to get that done, but I have not officially signed anything to designate it back to myself, which is what I would like to do.
Well, under that set of circumstances, I just encourage you to be in touch with your contact. And I think Mr. Katz said it's Mr. Smith at the Secretary's office, and discuss with him what needs to be done as it relates to that. And that's probably the best way of clarifying what you need to do as it relates to that.
Okay.
And these are common responsibilities and paperwork that are accessible at the Secretary of State's office and in communication with them. So we just encourage you to keep moving in that forward motion. All right. Are there any additional questions, or is there a motion?
I have.
Okay.
Mr. Denson, the emails that Mr. Katz from the Secretary of State referred to, he referred to a few dates that emails were sent to you. Did you receive them?
I recall, and that was what was interesting. So I do recall initially when all this became an issue, getting an email. But what I don't recall is in the last case, which is why I didn't know that this hearing was even happening. I went back and checked, and I did not receive a communication about anything. So I do recall at one time I did get something, but since then, I haven't received anything as far as a communication on, like the fact that even the last hearing that just took place, I think a week or two ago or something was happening. I had no clue that that was happening until like the day of or day before, which is why I asked for the continuation till today.
Thank you. I asked that question because particularly with long government bureaucratic emails. It's haphazard whether I receive them or I don't. I'll get one time, the same one, I won't get the next. So just that an email was sent doesn't mean it was received. So it was received once, doesn't mean it was received the second time. I know that from personal experience. I still always get Bill's emails, to be honest.
I get them all.
No, you don't know the ones you don't get.
Yeah, I don't know. All right.
I just have a question for Mr. Rector. So after
Sure,
hearing
Mr. Lau.
both arguments on both sides, is your recommendation changed?
It changes a little bit. My recommendation is still to find a violation, but to impose a $400 fine.
Hearing that recommendation,
Can I?
Mr. Katz, do you have any statement as to the reality of the case as it sits and that appropriation of a fine?
I do not, thank you.
Okay. Mr. Denson.
Mr. Denson, do you want to make a final comment?
I do on the fine. I really do, like I started off by saying, I want to get everything current and put all this to rest based off of current just life situation. The fine is a little steep for me. I don't know if there's any ability to adjust the recommendation of the fine. I want to work through it. I do.
Campaign finances.
I'm sorry.
Yeah,
Yeah.
yeah.
Still talking, I'm sorry.
You could pay it out of your campaign fund.
Okay.
That's one possibility. I've changed my recommendation. My original recommendation was to impose a $500 fine. I'm not looking to be declared, sympathetic by you. I understand that, but that's my recommendation. I adjusted it once. What the commission does is their decision. So, the commission will determine whether they want to accept my recommendation or go in a different direction. But, they certainly heard your comment right there.
Understood. Thank you.
Okay. Thank you, Mr. Denson, for your testimony and your time. Are there any additional questions of the commission members? Per the commissioner, I did not intend to interrupt you. I just was hoping to alleviate your feeling of that burden unnecessarily. Stress tends to accumulate in this commission sometimes. So, having heard all of these insights, is there a motion by the commission?
I'll move the recommendation of the executive director.
I'll second.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed?
No.
No. Okay, that.
That motion fails.
Okay. Is there an alternate motion or?
Well, the reason I voted no for that motion was because though I certainly understand Mr. Katz's position, reality is in my time on the commission, we have adjusted fines for much more egregious violators to level short than this. So with that, I'll make a motion to find the violation and a fine for $100.
A second.
All in favor?
Aye.
Any opposed? Okay, seeing none, the motion
Motion
passes unanimously.
Thank you very much, Mr. Denson.
Thank you.
The commission imposed a $100 fine in this matter.
Thank you.
All right.
And thank you to the commission.
Absolutely, thank you. All right, we're gonna move on to item 8, Lanham versus Buck, case 2013G-001. And for one last time before the commission, we have Mr. Hartman and Mr. Bride closing it out.
Mr. Hartman came dressed for the occasion.
Mr. Hartman is quite sick today.
Hmm.
So if you want to make an issue about that, I get notice of a hearing less than a week before it's scheduled.
There we go.
That's the way this commission has operated. That's why this commission is going away.
Oh,
Madam
okay.
Chairman,
Madam
before we start, I have to.
We're not really looking to get into that today. I'll let the chair take over, but thank you.
Well, Madam Chair, I'd have to ask and move for the recusal of Ms. Tavares. Ms. Tavares is serving on this commission in violation of Ohio Revised Code 3517.152E, which prohibits any member of the commission from serving more than one full term unless the terms are served non-consecutively. Ms. Tavares is serving a full term, which is consecutive to a 4.5-year term she previously served. And therefore, her appointment to this commission is illegal and she must recuse herself.
I do not recuse myself.
Okay, the commissioner has spoken, you have spoken. Got to have your piece one more time. All right, moving on to the case at hand. Again, case 2013G-001. Mr. Bride, please proceed.
I represent the respondents in this case. I believe this case should be dismissed. It's been pending for over 12 years. There has been no activity at all for the past 11 years, over a decade. That the committee itself no longer exists. Even if the case were otherwise timely, which is not, a continuing request for tell me who your exhibits are going to be, who your witnesses are going to be, has never been complied with by Mr. Hart. This case, the genesis of it happened, it wasn't filed until 2013, but the genesis happened in 2004 when Danny Buck beat Kurt Hartman in the primary to be a state rep. Danny won, Kurt lost, and Danny served for 8 years. And then in 2014, after he'd been term limited out of the House of Representatives, Danny Buck ran and won a race for probate judge of Brown County. And then he retired early in 2020, and Danny Buck has retired. He's moved on with his life. And Kurt Hartman and Mr. Landon apparently still wish to go after Danny Buck in this litigation. This case was filed in January of 2013, almost 13 years ago. We filed responses, we filed a motion to dismiss, and on March 7, 2013, the preliminary review happened. And the commission then, probably all different people, except for Phil, I think it's still there, and probably Chris, but they needed to vote. But the commission said, we can't tell whether there's a violation or not from the affidavits that we were filed. So we want some testimony, right? So I talked to Kurt and said, well, when can you guys be complainants be deposed? And I think Kurt, you're a complainant since you filed 6 of the 7 affidavits. He disagreed with that. And there's email back and forth. But nonetheless, since you wouldn't give us a date, we sent deposition notices in March of 2013. And complainant filed a motion for protective order as to Mr. Lanahan, not as to Mr. Hartman. I sent the email saying you want to apply to you or not, and I'll let you do that. And he said, I'm just not showing up. That's it. Now, the motion for protective order in April of 2013 was the last thing anybody did in this case for a year. But in 2014, Danny Buck was running for judge, and that apparently, maybe some other things, prompted Kurt Hartman to say, I'm going to notice the deposition of Danny Buck, who is a respondent in this case. And according to the rules of this commission, respondents don't have to testify. And I reminded Mr. Hartman of that. He disagreed, of course. We then, in an attempt to break the logjam in August of 2014, again, this is 11 years ago, respondents sent written discovery, which is attached, is accumulated to our December 1, 2014 memorandum opposing the motion. So it's part of the record. And the written discovery was saying, in the next year, from November 1, 2014 to November 1, 2015, is there any date upon which either you or your client could be available for deposition? Is there any date on which you or your client could be available for a hearing in this case? I also said, who are your witnesses? Who do you plan to use with? Thank you. Yeah. Who has information about this case? Who do you reserve the right to have it? And by the way, what documents do you intend to produce? What documents do you reserve the right to produce? What documents do you have that's relevant to this case? In other words, we're trying to find out who are your documents, who are your witnesses, and what information do you have about when it should be available so we can not fight about the date of a deposition, whether or not we can. Well, he never responded to that. Instead, he filed a motion to compel Danny Buck to submit the deposition on October 7, 2014. Or as I said, we filed a memorandum posting that on December 1, 2014. That was the last activity in this case for over a decade. For over a decade. There has been no activity in this case since then. It's complainant's duty to prosecute this case. It's not respondent's duty to say, hey, come prosecute us. Come after us. Do this. The complainant's duty to prosecute this case. And not once in over a decade has complainant filed a motion saying, please set this for hearing. Please set this for a hearing on our motion. Please set this for a hearing on other disputes I might have. Please, I want to appear in front of the commission. You need to move. Not once did he file anything requesting that. Instead, complainant did nothing but ignore and neglect this case for over a decade. Now, there's some case saying we don't have to even prove at some point that there's been any prejudice in order for that kind of delay to cause a dismissal or violation of due process. There's a couple Franklin County Court of Appeals cases which we pick because that's where you go if there were 119 appeal and county court. Well, now, one is Morgan versus Ohio Liquor Commission, the 2009 case, 2009 Ohio 3232. And they held that an unexplained 3-year delay was sufficient to vacate and reverse a finding of violation against someone for liquor violation. There's another older case, it's 1969 Franklin County Court of Appeals case, Emory Miller Hardware, 19 Ohio Ave 2nd 57, where they found a 2-year continuance to be problematic. And I'm not claiming that 2 years or 3 years automatically means it's a due process violation. Our procedure is a little bit different. But there is a line. And wherever the line is, over a decade is over that line. No matter how you look at it. It may not be a bright line, but this line can be as fuzzy as you want to. And once you get over a decade, even without proving that there's been a prejudice, this case should be dismissed. And in fact, there has been a prejudice. Mr. Kurt Hurton filed a motion saying, we need testimony. This commission stated in 2013, we need testimony. So you presumably, everybody agrees that the case can't be resolved without testimony. But when you're talking about testimony for someone who's waited 11 years with nothing to present testimony, you're not testifying about what you remember. You're testifying about what you did to might remember. If you remember now what birthday party you went to on November 13, 2011 was accurate in 2026 at this point, 2025, as it might have been if it were done in a timely fashion. Secondly, documents have disappeared by statute. The Ohio Elections Commission has its own document retention program. I understand that a lot of its documents have been told to throw away. But even if it's kept all of those, the boards of election of the counties and the Ohio Secretary of State originally had certified copies of all the reports and copies of all the information from those. But revised code 351710 D5 says that after 6 years, you destroy all copies of reports that are filed. And 351710 D6 says after 10 years, you destroy all information from those documents. So at this point, since complainants have waited over a decade and not moved this case forward, this case has not been separate hearing, those documents are gone. Nobody has access to them. I was trying to find the termination document because frankly, another reason to dismiss the whole thing is that the committee doesn't exist anymore. Why does Mr. Buff's campaign committee for state rep not exist? It doesn't exist because he ran for judge. And the Ohio Revised Code says you cannot have more than one campaign committee for all the offices in which you serve. And the Code of Judicial Conduct, according to advisory opinion 98-7 of the Board of Commissioners on Grievances and Discipline Committee, states that a candidate may have only one campaign committee, and if you held a non-judicial office but wish to become a judicial candidate, he or she must terminate his non-judicial campaign committee in order to establish a judicial campaign committee. So when Mr. Buck ran for judge, he decided he'd rather spend Mr. Kirk Hartman than he's violation of the district code of responsibility. If he violated that code, he suspects perhaps my client is too overly pessimistic, but he suspects that Kirk Hartman would be first in line to make an ethics charge against him. So the committee doesn't exist. So the response committee doesn't exist, and it has existed for over a decade. And in the motion to compel Danny Buck to testify that was filed by complainants, they say, well, Danny Buck doesn't have an exposure because the statute of limitations is gone and nobody can prosecute him for any of this stuff. Well, in fact, if Danny Buck can't be, if the statute of limitations is passed, then the only one still standing for that reason alone should be dismissed, even if it weren't a decade long, which it is. Thirdly, you know, in an attempt to break the log jam in 2014, we talked about that. We asked for copies of exhibits that you might use and names of witnesses that you might do. And by the way, that request was a continuing request. It stated that it was a continuing request. And it incorporated, I believe, Civil Rule 26E. And if you read Civil Rule 26E, Civil Rule 26E says, if you tell people who your witness to the documents are going to be, you need to supplement that up to the day of trial so you don't surprise them. Well, today is the day of trial. And as of today, we have nothing for over a decade from Kurt saying, here's who my witnesses might be. Here's what exhibits might have. And in fact, if I'm looking at the video correctly, Mr. Lanham isn't even showing up remotely. So to the extent that there is a duty to prosecute and a duty to present, it hasn't happened. For all these reasons, respond respectfully request that this case be dismissed.
Okay, thank you very much for your statements. Are there any questions? Commission members? Okay, seeing none, if the respondent, I apologize, the complainant would like to provide testimony, we're happy to hear it.
Well, not testimony. Mr. Hartman may want to make a statement on behalf of his client.
Yeah, I'd like to address a lot of stuff what Mr. Bry stated. And it's funny, I do find it kind of comical. He's saying, well, the committee doesn't exist and therefore you can't impose a fine against Mr. Buck. This commission had no problems imposing a $50,000 fine against somebody when that committee didn't exist. Now, I'm glad to see Mr. Knight is suggesting that maybe you shouldn't do excessive fines against people when you dealt with Mr. Denson just previously. But the fact that a committee doesn't exist does not preclude the issuance and imposition of a fine against the individual candidate. Your own precedent, excessive precedent, in my opinion, confirms it. But let's talk about what this case is about. This case was about and brought because Mr. Buck, as a state representative, in over 100 instances, was using his credit card, a campaign credit card, to purchase gas and could not support, could not establish the campaign-related nature of those purchases. We have purchases up in Delaware County. His district's down out in southern Ohio, along the river in southern Ohio. Yet he's up in Delaware County. Why is he in Delaware County? Because his daughter lives in Delaware County. And he's buying gas there. I don't have a begrudge him for meeting and going and seeing his daughter. But that really created a assumption that you're not using that credit card for campaign or official duties. You're doing it to visit family members. And that is an illegal conversion of campaign funds. And so we filed this complaint back in January of 2013. The commission at that time reviewed it and found sufficient grounds to proceed forward, rejected the motion to dismiss and said, go get the facts, go get your evidence, go conduct discovery, which is consistent with the rules of this commission. I know Mr. Bry is essentially saying, well, this commission sometimes follows its rules, sometimes doesn't follow its rules. That's its whole history. Good riddance to that. We tried to conduct discovery. And so what did we do? Chris, I need to share a screen, please.
You should be able to go up and click the share icon at the top, and that should be available to you.
Okay. Let me find it here.
These items have been pre-submitted to the commission in any way, or is this our only way of viewing them?
Mhm. I don't know
No.
what he's submitting, what he's
Well,
wanting to share at
it's,
this
it's,
point.
it's
but-
simple stuff. I mean, Mr. Bry was talking a lot of hearsay about this happened, this exchange occurred, you know, I'm trying to at least show it to you. So let me find it here.
Madam Chair, so is he submitting new evidence?
No, I'm presenting my argument to rebut what the falsehoods that Mr. Bry was stating, that we did nothing. So if the commission can see it, we issued a notice of deposition. And in that notice, but not only did we set it for August 19th at 2014, we identified various exhibits to bring his day calendar, planners, schedulers, to try to allocate where these gas purchases are occurring versus what official activities he might or might not have going on. So what happens though? We also sent discovery, and Mr. Bry did acknowledge that. And then there was an email exchange between Mr. Bry and myself. And that's not it. Here's the first email exchange, July 31st, 2014. I wrote to Mr. Bry that, hey, we sent you written discovery. You haven't responded and you're out of time. What I also indicated in that email is also on that date, you were served with 2 notices for depositions, one for Mr. Bupp, one for his treasurer. And those depositions were noticed for August 18th and 19th. In light of the non-response to the discovery request, please advise whether you and your clients intend to ignore those notices of depositions too. In response, Mr. Bry sent an email back on August 5th of 2014. As to the deposition notices, you're well aware, which is not true, but that you have no right to require respondents to testify in any fashion, whether by deposition or written discovery. And that I, Mr. Bry, have instructed his clients not to submit to the attempts to interrogate them. So Mr. Bry was clearly saying, we are not going to submit to deposition. Very well. So then what do? We do the next logical thing in the process. Fine. We file a motion with the commission to compel Mr. Bupp to submit the deposition. That was filed in October of 2014. We did something. Went through the process. And we've been waiting and waiting and waiting for a ruling from this commission on that motion to compel. The dilatoriness is not on our part. The dilatoriness is purely that of the commission. And so finally, when I get a notice, well, I get no notice of any hearing. Let me put that for it. This hearing being on December 4th, when Mr. Richter sent something to Mr. Bry, happened to have a conversation with Mr. Bry and discovered this notice went out. Nothing was sent to me. But what I did then is I reached out to Mr. Richter. I'll just give you, it was an email November 12th of this year. I said, while I've yet to receive the notice that Mr. Bry referred to, I would note that the procedural posture of this case is that Mr. Bupp refused to submit the deposition and a motion to compel his testimony is pending. And that's where things stand. For some reason, this commission has gotten in some great rush to find cases that have maybe fallen through the cracks on its end and cram them out the door. But the rules of this commission allow us to conduct discovery. And if this commission, though, I know sometimes it follows its rules, sometimes it just ignores its rules. Good riddance to the commission. If you're going to do that again this time, nothing I can do to stop you except take you to court afterwards, and I will. But this thing is not ripe for hearing. This thing is ready and has been ready for the commission to not sit on its ass and do nothing when
Watch
a
your
motion to
language.
compel has been
Watch your
pending
language.
for over, since October of 2014. That's all this commission has done. And you want to ignore the rules, because that's how you've operated. And thank God the General Assembly finally saw this commission for what it
Oh my
was.
goodness, this is moving into commentary. Let's keep this specific to the case.
Well, we got to follow
please,
the
with
rules
all-
or not? Are we going to entitle us to get discovery?
I'm sorry, are
or
you
not?
speaking to the case or are you pontificating on
I'm questioning
conjecture,
if this
political
commission is going
conjecture?
to
Please
follow
speak
its
to the
rules.
case.
I'm asking if this commission is actually going to follow its rules for once and allow discovery to take place. What really should happen is this matter, since it sat on the commission's desk with inaction by the commission, referred over to the Secretary of State's office as part of the transfer. Let the Secretary of State do what it wants to do.
Okay, if you're complete, are there any questions of the commission members? Okay. Seeing none, I imagine Mr. Bryan might have.
I just have a couple of points. On to it, but third part of this race. First of all, he's going about the rules. The rules of this commission, in particular, Ohio Administrative Code 3517-1-11B, and the Ohio Constitution, Article 1, Section 10, applies to the commission, give respondents the right not to testify. So the notion that we're violating the rules by not requiring the respondent to testify is false. We're complying with the rules when a respondent is not required to testify. I would also note that you cannot require production of documents from a party through a notice of deposition to his statement. And there are a number of case laws about it. That's just not the proper procedure or proper practice. When it comes to that. He said, well, I didn't wait 11 years. I sent an email to Phil Richter in November of this year. Well, I think he did. And that's more than 11 years from October 7, 2014, and slightly less than 11 years from December 1, 2014, which was the last thing that hit the equivalent. It was over a decade. And he's saying, well, it might have been over a decade. It might be, he doesn't dispute that there's a case law saying whoever's fault, and by the way, the Liquor Control Commission would want to fault, not the guy who served the guy up. I don't care whether it's the commission's fault or whether it's Kurt's fault or whether it's somebody down the street's fault that this case hasn't had anything happen in over a decade. It hasn't had anything happen in over a decade. That in and of itself warrants dismissal of the case. I couldn't think it's Kurt Hartman's fault. He naturally doesn't think so. He's blaming you guys for Phil or maybe me for something. But it doesn't matter. It's been on the docket so long that it would be a violation of due process to try to resolve it with stale and lost memories. And with frankly having Danny Buck be kept in limbo for over a decade and now unable to present a fully comprehensive case, his documents, mine and relevant are gone, as well as memories. So, you know, I still believe the arguments that I made, the delay warrants dismissal, the complainant no longer exists and he with his statute of limitations is gone as Danny Buck. And that his failing to refuse to identify witnesses and exhibits on a continuing request is a continuing violation. Prevents him from presenting evidence today, even if he had evidence today to present. So for all those reasons, I believe the case should be dismissed.
Yeah, are there any questions of commission members?
question to the executive director and then Mr. Hartman.
Sure, go ahead, Commissioner.
Why was the motion to compel a discovery never?
I would answer for you, but I don't know that I really do. At the time, they were going back and forth to try and see if they could get this matter moved forward. It was submitted, but then we got moving on other cases and just got lost in the shuffle. I can certainly apologize to Mr. Hartman, Mr. Bry, their clients and the commission for that. I'll take certain amount of responsibility for that myself. But I don't know that I've got a better answer than that.
Fair enough. So Mr. Hartman, I have a question for you. Almost 4 years to the day I've been on this commission. You've been in front of us over 10 times. That's probably a low estimate. You've been opinionated and vocal, which I respect. Don't always agree, but I respect. Never once has this been brought up, right? This was, basically a decade before I joined. You've had plenty of opportunity to bring it to the fore. And now, right, you want to throw around threats and sue us and all that good stuff. Was a mistake made, sure. But I guess I'm at a loss to understand why you didn't proactively do something in the course of the last dozen years. You had plenty of opportunity. I've seen you here personally a dozen times or more. Why has this not been important until now?
Oh, well, I think your question actually begs another question is, how did this case suddenly come up on the radar of the commission and quickly get scheduled for a hearing at the end? I mean, why wasn't its dormancy recognized by the commission for the past 10 years?
That is a fair critique, but it's a deflection.
Okay, but
it's
I
not
think,
an answer to my question.
but it does weigh. It's like, why all of a sudden are we rushing as the commission's going out the door and turning off the lights?
Well,
why are we rushing?
We've been asked by the Secretary of State and Legislature to wrap up as many cases as we viably can, and this is in best effort to try to accomplish that.
And this one got discovered.
That is the reason why. But again, why have you not mentioned
anything? And this one got discovered in some filing
years?
cabinet after the move over from Broad Street. I believe actually, and I can't tell you when. I believe I probably have mentioned it to Mr. Richter in passing during the past several years, once or twice here or there. I think I even, So I'm not going to say it. If the commission was in no rush to do it, the ball was in the commission's court. The motion had been filed. It was ripe for a decision. That's the commission's duty. I mean, we go to say, well, we screwed up. We should have done it sooner, and I do like to address just a few brief things that Mr. Bry was able to bring up in his reply. He says that the rules do not allow you not to submit to deposition. That is ridiculous. The rules allow for discovery. Now, as in all civil cases, if somebody wishes to invoke a privilege, including the privilege against self-incrimination, that is not done with a blanket. I'm going to invoke it. Don't even ask me any questions. That has to be invoked on a question-by-question basis. That is the law. And the law also is then, unlike a criminal case, when a person invokes the right against self-incrimination in a civil, which this is a quasi-civil case, the inference can be made against them that the answer would incriminate them. You cannot do that in a criminal case. But the invocation is not a blanket. You can't ask any documents. You can't ask any deposition questions. No, you can. If they want to invoke it, they do it on a question-by-question basis, and then there's a negative inference. Mr. Bry also says, well, you included document requests with your notice of deposition, and that is not proper. That is absolutely proper. I don't know. I'm quite trying to wonder where Mr. Bry got his education. I know he's been practicing a long time. The civil rules, which are applicable for the discovery aspects, provide in Rule 30, which deals with depositions. Rule 30B4 explicitly states the notice to a party deponent may be accompanied by request made in compliance with Rule 34 for the production of documents and tangible things at the taking of the deposition. So he stands here and says that was totally improper. The rules actually explicitly allow it. You're getting misled down a primrose path. The final thing I would just note on what he said, I think that's it for now. I already addressed about, oh, it was lost in a shuffle, but it suddenly gets discovered here, in the waning hours. The thing should be referred over to the Secretary of State. There should not be one that can be resolved at this stage. It should be taken up by the Secretary of State. And, because I would also, the final thing, I got notice of this hearing less than a week ago. Less than a week ago. I was on vacation. I just got back earlier this week on Monday. So we're now sending notices out less than a week to try to say that. I mean, it's just, how are you guys operating?
This is not new insight. So let's not beat a dead horse, okay? Let's just be reasonable. All right, can you please ask your question to the Executive Director and
I think
Commissioner?
it was a couple of years ago, but I remember a case where this issue came up around a respondent not having to reply to discovery because they don't have to make a statement of any sort. And I remember, being conflicted because the answer didn't really make sense. Could you just remind us from a commission perspective, what is the law here?
While we're acting in essentially an administrative capacity, there is always the potential that a matter could be referred for further prosecution, which would then subject that person to potential criminal penalties. And so that's where, for want of a better phrase, a refusal to testify or a denial of testimony is respectful of the respondent's position, because, not that this case would necessarily get referred for prosecution, but it could. And so therefore a respondent has an ability to essentially not respond because of the potential criminal liability.
Great. Thank you.
Do you want to proceed? I'd just like to keep things consistent moving forward, and we seem to
Fine.
overlap, so
Yes, no,
just let you.
Nope, I'm
No,
good.
you're good. Go ahead. No. Actually, can continue.
In what way?
The remainder of this case, I think it's just, there's a lot of overlap, so I might as well.
I'll be glad to answer any of the questions the commission may have of me. Not because he made the motion, but I would tend to believe that this is appropriate for dismissal. I'll be glad to answer any other questions the commission may have. But certainly, Mr. Hartman has indicated his desire to see it, passed along. That's certainly a possibility as well for the commission to take that action.
All right. Are there any additional questions of the commission members, or is there a motion at hand?
Madam Chair, I'll make a motion to dismiss case 2013G-001, Lanham v. Buff et al.
And Madam Chair, I will second that motion.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed?
No.
Okay, that motion passes 5-1, I believe we're in.
Yes, correct. That motion passes 5-1.
Okay, very good. Well, that seems to wrap up all the official business for the day.
Madam Chair, when is the decision letter going to issue? Since you don't have another meeting to approve the minutes, et cetera, what's the process going to be for the decision letter issuing?
They'll be coming out shortly. That's the best answer I can give you at this point, because, this is kind of new and different as it relates to our process. So, it's something that we will be working on.
Very good. Good riddance.
Oh.
Mr. Hartman, you are
Lovely.
so rude, but have a
That was
wonderful
classy.
rest
That
of your
was really
day.
classy.
Jesus.
Okay, thank you. Let's,
I
yeah,
hope
we
I
don't
hope you
need,
feel better.
okay, all. let's keep our composure regardless of people's actions. Okay. Okay, very good. Seeing that we have no other business, we did already approve the regular meeting minutes of December 4th. We are taking constructive and conducive insights to, you're more than welcome to approach and address the commission. We just ask that it be professional.
I'm retired, I'm not representing anything, I'm representing myself. And I just wanted to thank all of you for the years you've put in. Whether serving legally or illegally. And most of all, I want to thank Bill Richter and Chris Hughes because they've been probably the two state employees that I've interacted with by far the most. They've always been very responsive. And while I will say Bill would argue back and forth with me, which was good, I never got arguments from Chris. They were always responsive and people I believe of integrity. So I want to thank both of them. And if Betty was here, I would thank Betty too.
Yeah.
Thank you.
It's very kind of you. Thank you.
Thank you.
Appreciate that. Okay. Floor's open, but it looks like there's no additional insight. I just wanted to personally make a statement along the same vein that this commission, through our experience, albeit short and limited for some of these commission members, some, less than a year, some a few years, some longer, into several or one or two terms, but the executive director has been present, and Chris and his staff and team, and even Sandy with transcribing and being present to help take careful consideration of the notes. There's a high volume of work that transpires in this body, and although it is not always appreciated or seen as done in the way that others would ask to be fit, I can recognize and hear and know the level of output that is done on a weekly, bi-weekly, monthly, yearly basis, decade in and decade out by these professionals. So we just want to say thank you from us as the commission members. While we may come and go, there is a level of institutional knowledge that has been present and consistent, even with human error, to miss or have schedulings that don't hit the right cadence or the right timing. I can't think of any one of us that would be able to pull out the log in our eye to point out the fleck in somebody else's with carrying that considerable volume of cases. So we just thank you for your service. We recognize that this has been an extremely turbulent time for the commission, for all involved, the commission members, for those that are coming to provide their testimony, have their cases heard, just the weight of the political reality of how the commission is going out of this existence and moving into a different responsible party gives us all a lot to experience and process. And it's not always enjoyable. But we do say that the commission members here have tried to remain professional and kind and cordial in all cases. And I'm extremely grateful to have been chair with you as my commission members, because I'm not sure that all people would have handled this type of environment as well as you have. So thank you for the privilege of governing over what may have been the most unexpected and bizarre scenario of events in any of our careers, but we are so grateful for the prudence and the bulk of dedication that has transpired in the body of this commission. And our will and desire is that for those that are inheriting this exciting volume of work, that you will be able to shoulder, steward, and execute with excellence what you thought we might not be able to do so well. We really wish you the very, very best in that effort. And our heart and our will for those that have represented cases is that you will find everything that you're seeking in that structure. And I hope that it is a better structure, given we did not have any control over these ultimate transitions, but we do pray that it is helpful and fruitful, and that the will of the legislature is something that is a voice that was represented and saw a need, met a need, and that it might make a difference. But that is not our situation to monitor. We are just here to carry the torch of execution. And so we thank you for the time that you allowed us to serve you. But ultimately, gratitude here for all that have represented cases, all that have come and testified and aim to get into compliance, because ultimately our will as commissioners, and I think I speak for all of us when I say, was a desire to see Ohioans who were seeking to have some clarity and some closure, just experience compliance. So although we saw some exciting cases, most cases are not that exciting and are just people seeking to do the right thing and have the right amount of understanding for the structure in which they've entered to do goodwill. So our heart is that hopefully many more people were served well than those that experienced any type of turbulence. But we know that those aren't the things that are reported on, but those are the things that consistently happen through the sands of time, typically that are less interesting. And so we're thankful for all of the less interesting, and we also appreciate the character building and the exciting. So we thank you. Having said that, I'd welcome if the executive director has any statement of any sort, you're more than welcome to have the floor in any way.
Well, it has been beyond a privilege to serve in this position for all of these years. And it has been an absolute joy to serve with all the various commission members that I have had the absolute pleasure of serving with, from the first commission to the people that are serving here currently. I have been truly blessed to have an incredible array of members that have taught me so much, from essentially being a new lawyer and coming into this position in 1995 and 1996 until today. I could not have been in a better situation or dealt with more professional people. And honestly, the privilege of working with and against, to a degree, Mr. Bry and Mr. McTighe has been an incredible blessing in my life. And so, I appreciate the ability of having served here and having served the people of the state of Ohio. I am a blessed person, and I appreciate the opportunity that I have had here over the years. Thank you very much. And one last thing, my staff has been absolutely incredible and off the charts. Chris, Betty, Debbie, and Eugene have been, have made my job so much easier through their incredible efforts. And so thank you, Chris. Thanks to Betty. None of you knew Debbie, who worked very diligently before she had physical issues. And Eugene was a short timer that we brought on as a temp in our very first year, worked with us for about 8 months, and then left to go take another position. I have no idea what happened to him, to be honest with you. But it was fun having Eugene around. And if at the old commission, again, this is before all your respective times, if you continued to call 466 1375, is that, or 644-1375, up until when we got new phones, we were obligated to get new phones. You still heard Eugene's voice as the voicemail greeting on that phone, almost 20 years after he left the commission. Anyway, thank you, Chris, and thank you to my staff.
Okay.
Thank you.
Okay. So I can't help but do only what I know how to do. And I heard the name of Jesus and I heard blessing. And so I'm going to close us in prayer, and some of you are.
Madam Chair.
Yes, so you'd like to make a statement?
Yeah, I'd like to make a statement. Thank you. As the vice chair of this commission, I consider it an extreme honor and privilege to be able to show up as a public servant and continue to serve Ohioans across this state, from being a state representative and a local councilwoman back in the city of Garfield Heights. I will say this commission, as everyone clearly knows, and there's some folk who like to, drill it in the ground, that we are not a perfect commission. The system is not perfect. And I don't know if it was designed to be perfect. It was designed for people with differences to come together and find viable and reasonable solutions. This commission to me is an example of people from all different walks of life, all different experiences coming together and making decisions that impact the entire state. Once again, that is a tremendous honor and privilege. As Phil shared, I have been able to, over the course of, I think, 2.5, 3 years, listen to some amazing attorneys who are very compelling to draw you in. And having that legal background is very exciting because it's rare that I'm ever in a courtroom or anything of that expectation. So I thank you guys for being able to do that and really understanding election law. It is a very complicated thing here in Ohio. And to each commission member, thank you for serving with me, taking my calls, as I always call, individually, because we're not gonna violate sunshine law. And to the staff, Phil, you are the Ohio Elections Commission. You are. And you have done all that you could. And I will say, the state has not honored you properly. You were not giving all of the tools. So while there can be criticism, we know that bureaucracy creates a lot of things, and a lot of times governments are challenged. And this commission has shown me that over the course of 2.5, 3 years. Chris, thank you so much for taking my calls, responding to my emails, and not responding to my emails, but it's all good. When I call you, you always answer. And that is what I want to say as the vice chair, who will never get to be the chair, but that's okay. I've loved every bit of the last 2.5, 3 years. So thank you all.
You can transfer it real quick and.
Yeah, you know what?
You could
That's
say
a great
to the chair,
idea.
or resume.
No, I'm teasing. Thank you, Vice Chair. We appreciate your sentiment and statement. I apologize, other commissioners. Does anybody else have anything they would care to share?
I would just like to share that I've really appreciated all I've learned from Phil. Chris, you've been wonderful to work with. But Phil, I've really learned a lot from you, and I appreciate that you've stuck it out for 30+ years. It's not an easy job, as was shared. And as our chair shared, we're not always given the tools that we need in order to do the job that is needed to be done for the residents, the citizens of Ohio. So I appreciate all that you've done, Phil. I appreciate your teachings.
Thank you.
And your support as the executive director of the Ohio Elections Commission. And just for those naysayers out there, this commission has always operated above board. I filled an unexpired term, and this is for Hartman, and was reappointed by the second governor. The first appointment was by Governor Kasich. The second appointment was by Governor DeWine. And I did no different than any other commissioner that filled an unexpired term. I got my own term. Democrats, Republicans, and I'm not sure if any independents had an unexpired term that they completed and then were reappointed. But the bottom line is that's the way it operates. And so I did nothing wrong, and that's why I never recused myself from any of the cases that came before this commission. This commission has always acted above board and has been apolitical. It has done the duty to keep people in compliance with election law. And so I thank you all, and I thank all my commissioner friends and supporters here. I think we've all worked very, very hard together, and I think the evidence shows by the work that we've done. Thank you.
Thank you. By the way, Mr. Shapiro was an independent who was reappointed.
Wonderful.
So there's precedent.
And both parties had that occur over the years. When it was originally raised, back when I went back and looked, and I can't recite them off the top of my head, but both parties had persons along with Mr. Shapiro, who was the one independent that did. So there you go.
Okay, well, I would love the honor to close this in prayer, and then I'd ask that you all would formally close the meeting, if you'd be so kind and gracious one last time. So, dear Lord, we enter your gates with praise for all the opportunities that you give each and every one of us every day, Lord, just to wake up one more day with breath in our lungs and purpose, although sometimes the position or the role may be waning or differentiating, Lord, we know that that is not who we are, but how you call us to execute in the moment, in the day, and in the weeks and months and hours that you assign those roles. So Lord, we just pray today over the members of this commission and specifically the staff, that they would just have complete and perfect peace in knowing that you are present with them as they navigate these uncharted waters. And we also pray ahead for the body that will receive this duty and challenge. Lord, we pray that they would have perfect peace. We know that the merging of entities or the handoff of government work would be remarkable if it were less than messy. And if the intended writing of the legislature actually fit well without some type of cleanup needed. So we just pray, Lord, for all the parties that will be impacted by the changing of these seasons. And we pray for all of the Ohioans that will navigate this bridge, this process. And we just pray that they would have what they need, that there wouldn't be a gap in service or purpose for them. They'd have their questions answered. They'd have their cases supported. And Lord, we do ultimately pray for better processes, although it was not our will, it was not our directive. We just pray, Lord, that we were faithful to execute in the time that we were given, and that you would use all of this for your glory and your purpose. In your mighty name we pray. Amen. That's all I have, friends.
Madam Chair, oh, I'm sorry. Go ahead.
Go right ahead.
Madam Chair, I'd like to make a motion that we adjourn today's final Ohio
We die.
meeting.
Absolutely.
It's true.
Yeah.
All right. We have a motion and commentary on the floor. Was that an official second? Was that a? Very good. Okay. All in favor? Aye. Never has there been a stronger, more unified aye. All right. Thank you very much, everyone, for your patience and grace.
Oh,
Everybody's heading to Schmitz now?
Yeah, that
I will
was.
be over at 12. I've got to do something. in my car. Well, I'm gonna head over there.
Huh?
Hartman coming?
Oh, why don't we?
Are we done, Chris?
We could.
What
What about Mr. Harris? Oh, yeah. I'm.